Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which we've reviewed before. This book comes from LexisNexis and the title of the book is Insolvency Law, Corporate and Personal, and the edition is now the fourth edition. It's been written by two people, Andrew Keay and Peter Walton. Now the title we've given for our book review is the following: a straightforward yet detailed statement of law accessible to students, practitioners and unrepresented parties alike. And that's basically the position with the book. Let's have a look at it first of all. It's a paperback. There we go. It's a heavy book actually. There we go. The spine and then the back of the book. It's got a lot of blurb on the back. I borrowed a little bit of it, not very much, but you can actually see from what's in the book that there's a lot of updating of the rules. More on that in a moment. I open the book at the back. It runs to 734 pages. You see the index. The index is by paragraph numbering, which is a sort of structure that they've adopted, I think, as a house style for this particular publication. It says references are to paragraph numbers, just in case there's any confusion. Now the front of the book is, there is the front page. You can see the details of the authors, and then you can see the blurb from LexisNexis, and then the contents section. It's split into various parts. First part's the introduction, then you get into chapters running all the way through. Everything that you need to know in the various contents section. A lot of chapters involved. Excuse me. The final chapter is chapter 48 on offences. This is actually the criminal side of it. Then there are the prefaces, and a lot of them actually. Preface to the first edition by the two authors. Then preface to the fourth edition, which is also helpful, and then an abbreviation section, which I do find very helpful. One of the problems with insolvency practice is that there are quite a large number of abbreviations, and you do need to know what you're talking about at any given time, and this does actually help. Then we've got the acknowledgements and the table of cases, quite a large number of cases set out. And then, of course, after the table of cases, we have the table of statutes. And guess what we have after that? When I find them, table of statutory instruments. And which are, of course, quite important, bearing in mind the subject matter. Then there's a short introduction for part one of the book, explaining and then it expands on that and so forth. And you can see there's the paragraph numbering, and then as we go through you can see footnoting at the bottom as well. So it's very much the standard house style for LexisNexis and all the major English legal publishers. Now what do we say about this book? Well, as I say, we've reviewed it before, and it's part of my practice to deal with bankruptcy, so it's a book that I found helpful personally. What we say is we've always yearned for a book which sets out in a simple manner the rules regarding insolvency, whether it's corporate or personal, and which would appeal to a range of readers with differing levels of knowledge, and that's what you get here. And of course there are quite a few books on bankruptcy out there today, although the subject matter itself can be both mystifying, terrifying, and of course confusing for many people worried about their future. We're therefore very fortunate, we think, to have this title as a paperback, Insolvency Law, available to us now in a fourth edition from LexisNexis. It's been written by two eminent professors, Andrew Keay from Leeds and Peter Walton from Wolverhampton. I imagine it's Keay, it may be Keay, but I think it's Keay, he pronounces his name. Do start the book by reading the two prefaces, which are right at the beginning, which will assist you in knowing how to use the book and explain what is new in it for this year, because there have been quite a lot of changes. There's some detailed recent developments are added and commented upon in case you're looking for any specific information. probably may need to do, I would have thought, with the insolvency rules themselves. Now, the two authors mention that the last edition, the third, was written some 5 years ago, which is quite a long time in insolvency law terms, they say, considering the changes which have taken place since 2012. And the writers explain they decided to await the overhaul of the insolvency rules, hence the delay. But the wait, we think, has been worthwhile because we find the structure of the book and the clarity of writing extremely helpful for all levels of reader. And of course, new to this edition, the authors have taken into account the latest version of the insolvency rules where appropriate, and practitioners can notice that the book does not go into any great detail in many parts concerning procedure, which is really outside the scope of the work, and you can get that information in a number of different publications that are now available. Clearly loose leaf work as well. Depends very much on what type of insolvency one is dealing with. And what we found particularly helpful for the fourth edition is the explanation of the decision-making process in insolvency regimes based on both the statute and the new rules. And as Keay and Walton declare, quote, the rules surrounding decision-making will undoubtedly become a critical aspect of insolvency practice. And for that reason alone, this book is probably your best purchase if you're involved in insolvency work and need to advise on it on a quite a regular basis. And the final word comes from the first edition, which I was browsing through, which explains the value of insolvency law for current practitioners. The authors wrote at that time that insolvency was until recently subsumed under company law and commercial law. They then concluded that over the last decade, insolvency has become a separate discipline within law. Absolutely, because things have changed. And I can certainly recall a time when insolvency wasn't seen in the way it now is because of the statutory changes and in fact quite a lot of case law. And as the next decade unfolds in a post-Brexit world for us, the original readership envisaged by the two professors has probably expanded from merely the scholar and the professional to cover the unrepresented party, of which there are many, of course, now. And of course, we remain very grateful to the writers and publishers for continuing to produce these new editions. So thank you very much. The book was published on the 20th of June 2017 and laws as stated at the 1st of March 2017. I'm recording this in the autumn 2017, so it's relatively fresh. And of course this is, as I say, this particular book is very useful from the point of view of giving you the most up-to-date position on the rules. There's the book again. It's a heavy book, as they say, and it runs to 700 odd pages. Opening it up in the middle, Chapter 12, Introduction to Winding Up. You see the structure, it's chapter number, the paragraph numbering there, and then the footnoting. A lot of detailed footnoting, which you can probably make out there. As I say, you've got right at the back of what I think is actually a very detailed index, very helpful too. Thank you to the two professors, and thank you very much to all concerned for making this subject more intelligible. It is a very difficult area to practice in because obviously it's a person's livelihood, both either personally or in a business sense, that we're talking about. So this book is invaluable as a friend for those in need in those circumstances. So thank you to all. Bye-bye.